recent years, there has been increased resort to third-party funding in litigation and arbitration, including investor-state arbitration. The use of third-party funding in investment arbitration has prompted a debate on whether it should be regulated, and if so, how it should be regulated.
ICSID received a diverse set of comments from stakeholders on third-party funding, ranging from those who did not support any regulation to those who wanted to prohibit its use entirely.
Proposed Arbitration Rule 21 approaches regulation of third-party funding from the perspective of avoiding conflicts of interest between the parties and the arbitrators selected for the tribunal. The proposed rule requires parties to disclose the fact of third-party funding and the name of the funder. There are several aspects to Arbitration Rule 21 that should be considered.
First, it is complemented by a revised declaration of arbitrators in Schedule 2, which requires arbitrators to confirm that they have no conflict with any third-party funder disclosed by the disputing parties. Second, it applies to both claimants and respondents. While we typically think of claimants as the users of third-party funding, increasingly respondents are also obtaining such funding, and disclosure by all parties is necessary to avoid conflicts of interest.
Finally, third-party funding must be disclosed at the earliest possible moment after registration. For example, if a claimant has third-party funding before they file a request for arbitration, they would have to make their disclosure as soon as the case is registered. If they obtain third-party funding later in the case, they must disclose it as soon as the funding is obtained. The same requirements are imposed on respondents.
Defining third-party funding is difficult because it is evolving quickly. As a result, we took our inspiration from definitions in investment treaties and other rules addressing this topic. The definition of third-party funding proposed in Arbitration Rule 21 has several elements. It is defined as the provision of funds or other material support for the pursuit or defense of proceedings by a natural or juridical person that is not a party to the dispute, to a party, its affiliate, or its legal representative. Note that the funds may be by way of donation or for remuneration, so long as they fall within this definition.
Finally, the actual disclosure of the terms of funding or the funding agreement are not required by this rule. This is because these are not needed to avoid conflicts of interest. As is the case today, parties may request a copy of the funding agreement where it appears relevant to an issue in dispute between them. It will be within the usual discretion of a tribunal to address such disclosure.
We hope this introduces you to the proposed provision on third-party funding. Please consult the working paper on proposed amendments at pages 129 to 138 for further details, and we look forward to receiving any comments you may have on the proposed rule.